Good evening, Vijay sir.
Hey,
Good evening, sir.
Kamlesh, how are you?
Fine, sir. Fine, sir. Welcome, sir.
Hope you are able to hear me.
Yes, sir. It's very clear. Yeah, sure, sir.
Okay, that's great. So we are starting at 7, right?
Yeah, 7, sir. Yes, sir. So we'll be starting
Okay,
at
great.
7 o'clock. Yes, sir.
Good evening, everyone. Sir, shall we start?
Yes, sir. Shall we start?
I, Utsavi Patel, invite you all to embark on this transformative journey of the professional growth, collaboration, and innovation. Let us embrace the challenges and opportunities of the 21st century, guided by the expertise of all the speakers. Welcome to the first ever 1 month national level online faculty development program on teaching laws in the 21st century, a collaborative effort between the Law Teachers India and Gujarat Maritime University, Gandhinagar. Today we have our faculty coordinator, Dr. Basirat Fatima, currently working as an assistant professor at Faculty of Law, Integral University, Lucknow. Welcome, ma'am. Over to you.
Thank you, Utsavi. I hope I'm audible to all of you. All right. A very warm good evening to everyone. With permission from Dr. Vijay Kumar Singh, sir, I welcome all of you here on this FDP, 1 month FDP on teaching law in 21st century. Sir, I'm pleased to introduce you and welcome you today for today's session. So, ladies and gentlemen, today's resource person is Dr. Vijay Kumar Singh, sir, who is Professor and Dean, Faculty of Law, SRM University, Faculty of Law, Delhi NCR region. Dr. Singh is an experienced legal professional, having worked with industry and academia too. He has been working with Indian Institute of Corporate Affairs. It's a think tank and capacity building institute. Sir has worked with Competition Commission of India too. Sir was also associated with University of Petroleum and Energy Studies and Hidayatullah National Law University, Raipur. Sir has also been a law clerk to Honorable Justice at the Bombay High Court. Dr. Singh is a doctorate in law with basic degree in science, followed by gold medal in his LLB and LLM from Nagpur University. Dr. Singh has authored a book titled Corporate Power to Corporate Crimes, Understanding Corporate Criminal Liability in India. Sir is a certified trainer on managing disputes and difficult conversation on the board by Center for Effective Dispute Resolution and a mediator by ICADR. Sir, without further delay, I request you to kindly enlighten us on strategies for teaching corporate laws in Indian law schools. So please.
Thank you, Professor Fatima, and for such a nice introduction. And I must congratulate you for keeping it short. Thank you for that. Teachers, when speak to teachers, it is basically we should keep our introduction short. That is what I have learned till now from my seniors and my teachers. Today's session, we are focusing basically on teaching strategies of corporate law. And teaching to teachers about teaching strategy is a difficult terrain. So actually, Dr. Kalpesh has put all the resource person in a difficult terrain for bringing them up in this particular occasion and telling them to teach some strategies to teachers. I personally believe that we are all in an exercise of learning and unlearning. So there are certain things which we do in our classrooms. There are certain things which we don't do in our classrooms. So this interaction probably would be a joint learning. So I don't propose it to be a lecture from my side because I think we are all colleagues and it is better to interact and discuss rather than I giving a lecture to you. Though I have prepared a presentation because that keeps us going in a structured format because there are some components which I would like to discuss in today's meeting. And feel free to utilize your chat box. I hope your chat box access is given to you. So you can, put your questions there to everyone and so that they can read the questions. At the same time, I will be also looking at the chat box and interacting or maybe simultaneously engaging with your questions. So that is what is the format which we will follow. Coming back to the topic which is concerned, let me share my slides with you so that you are able to see it. So topic is quite interesting. It says strategies for teaching corporate law in Indian law school. Now, when we talk about this, first question which comes to our mind is that what is corporate law? Because that needs to be defined first before we go into the details of the strategies, because different subjects have different strategy to teach. And probably in this 1 month program, you would have learned already some strategies, and different strategies could be applied to different strategies as well. So it is not a situation that a teacher who is teaching family law will not get benefited by learning from the strategies in corporate law. It is basically teaching strategies are useful across, and you can utilize one strategy for another teaching, another strategy for another teaching. Unfortunately, in India, we have not done enough of research as far as teaching strategies are concerned, teaching learning methodology is concerned. We don't focus much on these aspects. However, if you go to US, teaching and learning pedagogy is quite rich. Similarly, in UK, you will see that the law schools are following a different kind of a pedagogy, and they do deliberate upon these issues. I must say that Teachers India's initiative to take up this, approach of teaching strategies, and they are coming up with a book also, as I am known on this particular aspect. Probably this is going to help all the teachers who are new to the profession, as well as teachers who are senior would be able to share their experiences with the young lot, and there will be a mutual learning. Coming back to my question, as I said, what define corporate law? What do you understand by corporate law? So my first question directed to you people would be as to what is corporate law as per your understanding. So what do you think? Like, you may put across your points in the chat box. I'll be happy to have a look at it. What is corporate law if we have to define it? Yeah. I hope I'm able to see your chat box. Give me a second. Yes. If anyone would like to give any input, what is corporate law? Okay, somehow I am not able to see my presentation and simultaneously the chat box, but I will try to follow it from here. Okay. Good, good. So it is law governing corporate houses, including corporate governance, governing all companies, law that governs functioning of companies. Good. Law relating to body corporates, contract, company. Well, fine. So you are basically concentrating around the corporate or subjects which is relating to company, right? So this is what we are generally saying that is corporate law, corporate business, yes, and corporation of law which deals in commercial in nature. Okay, commercial in nature, that is a quite broad stream which is there. Well, so when we say define corporate law, yes, you are right. We are having so many things in it. And ideally speaking, if you will see the definition, which is, there, or there is, in fact, there is no definition as such of corporate law. Corporate law is a term which has emerged out of the company law over a period. The practice of company law has increased, and that is quite visible from a fact that each of the terms which has been outlined by you, like, for example, we are talking about investigation, we are talking about amalgamation, or maybe you are talking about paid up capital, share transfer, maybe share activism, or corporate governance. These are all independent streams which have come up in the corporate law practice. So when we say corporate law, it is a very broad frame, and that includes many things in it. And I will touch upon shortly about the different specialization areas which have come up as far as corporate law is concerned. But broadly speaking, when we say corporate law means something relating to corporate affairs. So first we need to go to understand what is corporate affairs. But before that, we go to understand what is corporate affairs. Let us understand that corporate as such involves body corporate, or as such involves a company, or maybe a artificial entity which is there, which has been created by the permission or concession from the law, and there are different jurisprudential theories around it, which we will touch upon in a while. However, when we talk about corporate law, we basically have, as teachers, we don't concentrate much on its regulatory bodies or the regulatory ministry. So this I find that whenever someone has to teach company law, they will just turn to Avatar Singh, or maybe they will have a Companies Act, Bare Act, and they will start reading the sections, maybe starting from preamble, a bit of a history, and they will go through it. One major thing which I feel one of the strategies of teaching corporate law should be that a teacher who is teaching corporate law, any subject, should begin with scanning through these two ministries' website. These are very, very important ministries. One is Ministry of Corporate Affairs, that is called MCA, and the other one is Ministry of Finance, that is which has got different departments. Why Ministry of Finance? Because Ministry of Finance deals with your securities, and it deals with also RBI, all matters relating to money, anything involving cross-border financial issues will be taken care of by Ministry of Finance. If you are too much interested in this particular area and you are working in this particular area, I would also suggest Ministry of Commerce, because that is also from an international trade perspective, that is a important ministry to follow. So these are the three ministries which I feel that each teacher of a corporate law, even otherwise, all citizens should follow and try to see what is happening on their website. Look for the latest updates, latest information, because this will provide you the latest information to give to the students. Now, many people say, that we are in a Google age, and there is what is the requirement of sharing information? We should share knowledge with the students, and we should share our wisdom with the students. But unfortunately, whenever I go to the classrooms, I find that irrespective of the fact that there is ChatGPT, AI, there is so many things, nobody can replace a teacher in the classroom. Because unfortunately, the students who are there in the classroom, majority of them are not prepared for the class. So this is a huge challenge. And in fact, we as teachers also should put a hand on our heart and ask ourselves that whether we prepare for the classes before we go to the classroom. And this is something which should be the basic question which we should ask before every class. And these two, departments which I am talking about, Ministry of Corporate Affairs and Ministry of Finance, are important websites. And you can go to the latest updates. You can see there are a lot of resource material also shared on these particular websites. This will help you on doing good research. This is important. Secondly, Ministry of Corporate Affairs or Ministry of Finance, they are having their, different organization associated with it. For example, in Ministry of Corporate Affairs, we are having Indian Institute of Corporate Affairs, which provides many information. There is NFCG, National Foundation on Corporate Governance, and likes. Similarly, in Ministry of Finance, there is an institute in Faridabad on, by Ministry of Finance, which keeps on doing a lot of events. So these are the, other organization under the ministry which needs to be keep a tap on. Why I am referring to these ministry, there is one important thing which you can notice about Ministry of Corporate Affairs, that initially it was not a ministry, it was a department. So this was called Department of Corporate Affairs. And then subsequently the amount of companies increased, the function of these companies increased. There was a requirement to see that there is an exclusive ministry which takes care of the corporate affairs, and that is how Ministry of Corporate Affairs came into existence from Department of Corporate Affairs. So this development is also quite an historical importance, because that gives you an understanding that how corporate affairs has grown in the country over the years. Now it is one of the most important ministries which takes care of all the companies, or you can say overall ease of doing business and economy of the country. So this is for research side. So my first leg of presentation, which I gave it to you, is basically to do research. So first strategy for sharing with you is doing research, and you should know where are the resources, where you will get the information, where you get the latest information. And for corporate law, you get the information from Ministry of Corporate Affairs and Ministry of Finance. Now let me move further and talk about something. What is corporate affairs? So this is the important question to ask. What is corporate affairs? And if you go to the ministry's website, MCA's website, it tells you their business rules, and it tells you their scope of business, what they do, and you will find that it regulates 3 legislation majorly. Now 4th one is added recently. So one legislation which they regulate is Companies Act, and then other than Companies Act, they regulate Partnership Act. Then there is LLP Act, that is Limited Liability Partnership. And then now Insolvency and Bankruptcy Code has been added. And the last one, the 5th one, is the Competition Act. So these are the major legislation which is taken care of as Administrative Ministry. Corporate Affairs takes care of that. Now, when we say corporate, this relates not only to the company law, but also it relates to Partnership Act, it relates to Limited Liability Partnership, which we ignore generally. So these are the legislation, and definitely Insolvency and Bankruptcy Code, because a portion of the company law is now specifically dealt with by the Insolvency and Bankruptcy Code. So there's a new area which has emerged, and an important area which has emerged. So growth of corporate sector we have seen over the period, and there is also a growth of corporate power. So there is a lot of power which these companies wield, and we have seen this particular thing in our country. There are a number of protests which has happened off late, and these companies have been accused of keeping power with themselves, and this is not a new phenomenon. If you go back and see different reports immediately after independence, there were a number of reports which were submitted. Either you talk about K.C. Das Gupta committee report or Mahalanobis committee report, or many other reports which have talked about concentration of power in the hands of few corporates. And this has been a big challenge. And in fact, our constitutional philosophers, our constitutional makers have thought this through. And accordingly, they have talked about economic justice in constitution. And there are provisions in directive principles of state policies which calls for bringing in that particular equality and interacting with that equality. We are talking about equal protection of laws, and then at the same time freedom of business, but that freedom is not completely unwielded. There is a regulation over that particular freedom. And that is where this corporate affairs comes into existence. So corporate affairs is not independent as such. It has to interact with society, and those societal norms also cut across the corporate norms. And this we will see in a while, because there's a new emerging area which is coming up is ESG, that is, environment, social and governance part of it. So we'll talk about it in a while. But growth of corporate power is a big question which needs to be understood very, very clearly by us. Another important development which has happened simultaneously after 1992, probably after liberalization, is rise of securities market. So you find that there is a huge amount of development in the securities market. Just see and watch the regulations framed by SEBI over the period, and there is so much to do around this. In fact, I find that there is a separate legislation itself which has come up, and this year I taught it to my students, is International Financial Services Authorities. Kalpesh is in Gujarat and it is in Gift City, and that is a complete new thing which has come up. Now, many of the corporate law scholars are not talking about it. Probably they should include that compulsorily as one lecture or two lecture for their students, because the students must know that what are the new developments happening. The former Secretary Ministry of Corporate Affairs, Mr. Injeti Srinivas, is heading that particular IFCA, and that is completely a different regulatory space altogether. Just like SEC, it is a completely a different space, because the laws of the country does not apply to that particular place. There is a separate law for specifically enacted for Gift City. I'm talking about International Financial Services Authorities. So it is quite an interesting development as far as corporate law is concerned. One should watch for that, what is happening around there and what are the developments coming up. Now, over a period, due to this growth of corporate sector as well as securities market, there is a lot of regulation requirements, and there is a lot of regulatory requirements which has cropped up. And this has given rise to a number of regulators. So we have already seen constitutional law scholars would know about Sampath Kumar's case and L. Chandra Kumar's case, these are the things which we have discussed already, that legalization of tribunalization of justice. There are a number of things which is happening around it. But it is inevitable because the government itself cannot regulate everything. So they need people who will be doing, they need organizations who will be doing, and that is giving rise to the different regulators. One example is IFSCA, and there are plenty of the examples like IBBI and many of them which has come up now. And these regulators regulate, and for regulating, they have their own legislation, they have their mechanism to deal with it. And this gives rise to a body of law, which as corporate law academics, we need to follow. So we cannot say at the end of the day, because I also sit for a number of interviews, and when I interact with the young scholars or young teachers, they are doing their research in insolvency, bankruptcy. But when you ask some basic question like TK Vishwanathan committee reports, introduction chapter, difference between financial and economic laws, probably people are not able to answer that. So these are the things which we as teachers should be very, very clear about. We should be following it. We should be updated with those information. It may not be possible for you to read all legislation, but at least you have to follow the news. And that is a very, very important aspect. I give you the second tip of the day. That is, you should compulsorily, as a corporate law professor, read one business newspaper. So this is something which I tell to my students as well. And we as teachers also, it is applicable to us, because you have to follow the news on a daily basis. You can subscribe your favorite newspaper, any newspaper which is there. But if you are a generalist teacher, if you're not a corporate law teacher, then you don't have to subscribe to a business news. But if you are a corporate law teacher, definitely you need to subscribe to a business news. Your general newspaper like Hindu and those things will not do. You need to subscribe to a business newspaper, Economic Times, Business Standard, whatever suits you better. So this is the second one. Now let me move forward and talk about something more. And this is going back to history. And this is my third tip for you people, that always keep history in mind. So as professors, as teachers, your first few lectures, sessions should be ice-breaking session with the students. I know every year you cannot break ice with the student, because you know the students and you know that how notorious they are or how good they are in your class. But this is not the breaking ice with the individual. This is breaking ice with the subject. And it is very important for you to break this ice with the students. So straightforward, if you start with section 1, preamble, then definition clause, they will lose interest in the subject. So it is very important to give them that historical context, to give them that anecdote, to give them that your experience which you have done. I have a number of experiences to share with them, from Competition Commission of India, Indian Institute of Corporate Affairs, my interactions with National Company Law Tribunal members and all. So similarly, you may also have different experiences. Either you as an intern, maybe a law clerk, you have worked somewhere, maybe in a firm you work. So you can begin with that particular thought or that interaction with the students. But at the same time, teaching them history is very important in few sessions. Not history in a sense that medieval history or history of Ram Janmabhoomi, but history of corporate law, which subject which you are teaching. Giving them a historical background would be very, very essential. Like, for example, if you are teaching insolvency and bankruptcy court, you need to tell them why this insolvency and bankruptcy court came into existence. What is the historical background to it? And if you see TK Vishwanathan committee report, it has talked about it in quite a detail. Similarly, if you talk about company law, if you have to tell that initial company law, it all started with East India Company in 1600, when the first concession by the Royal Charter was granted to this company to do, things. So this is something which, is important for you, and that needs to be told to them. Similarly, in UK, this Joint Stock Companies Act in 1844 came up. And after that, we also adopted that particular philosophy. And then in India, the first company law which came up was 1913. And interestingly, we celebrated 100 years in 2013. So when we revamped our complete company law in 2013. It was almost 100 years when we got our first law. Now you would note that this Companies Act 1956, which came up after independence, was on the basis of recommendation by C.H. Bhabha Committee. Now, as teachers, over the period, say for example, it cannot happen in a day. I have also not read this C.H. Bhabha Committee report yet fully, but as teachers, we should be at least glancing through the contents, that what this report actually talked about, so that you have a sense at the back of your mind that yes, I have seen that particular report, and it is important for you because 1950 or the 1956 Act, the recommendations all came from C.H. Bhabha Committee report. It is not a small report, 500 pages report, and it takes time to read. But yes, not in a semester, probably in 3 semesters when you teach company law. And generally in your institutions, there is a shortage of corporate law faculty. So I always tell, and this is my further tip. I lost my count, so probably somebody can tell me what is the count. But when it is important to teach corporate law, and there is always a demand for a corporate law teacher. So taxation and corporate, these are the 2 areas which are very, very much in demand. I don't say that the teachers in constitutional law or different other subjects are not in demand, but definitely the teachers in corporate law is in scarcity because there is a lot of you can see developments happening. It is very difficult to keep pace with this particular legislation, and I find that many of the young teachers who have completed their LLM in business laws shift to the non-corporate law subjects, and I find it a bit intriguing, as well as feel somewhat bad about it, because I feel that you have put in so much of effort in corporate law. You should continue with that particular effort. I understand that there is a lot of effort required because constantly you have to update. Every day there is a new decision. Every day the legislation is also changing. Like insolvency and bankruptcy code actually has done so much of changes in last 4 or 5 years. I think no other legislation has done that. So keeping track of it, pace of it is difficult, but yes, it can be achievable. Then coming back to the history, 2013 law is completely transformed. So the section number changed, everything changed. So I don't know how many of you taught in 1956 Act, because I think if you have taught 1956 Act, then you are sufficiently senior. And because I read 1956, I taught 1956 in couple of batches. 2013 law, when it came up, it changed a lot of things. However, I am sure you people have read Ramayya, and that is an important book as far as company law is concerned. And the latest edition, which is there, is being edited by Arvind Dattar. Arvind Dattar is the chief editor, and there are a number of people who have edited this particular book. And in his preface, in his introduction, he has written an interesting one. I would say that all of you should read that. And he brings his experiences because he was the lawyer for Madras Bar Association, and he was, fighting that NCLT case, and his views on the legislation has come up in that preface. It is quite interesting. As teachers, as students, you should read that. That will give you an important perspective. The baseline of that particular argument, which Mr. Dattar puts up, is that we were trying to concise this particular law because there were about 700 odd sections in 1956, which transformed into 460 sections now. However, we have done a lot of delegation in that particular legislation. So he counts, in fact, and I'm at present, I don't remember the exact number, but about there are about more than 100 places where as prescribed has been mentioned. That means somebody has to prescribe something, some rule around it. So he says that it has not done service to the thing. There is a lot of prescription. That means there will be a lot of delegated legislation around it, which increases your work. So wherever there is an as may be prescribed, when you are going to teach your students, you have to see the prescription. What is the rule associated with that? So this is an important area which needs to be also touched upon by you people. Now, there are a number of amendments which has happened, 2015, 16, 20, 21. I think there is some amendment also slated now when the parliament is in session. So point here is that all these amendments have brought some incremental changes. One comment from my side as a corporate law professor, I would say, is that when Companies Act 2013 came up, it was brought under the cloud of three big scandals which has happened. One was Sharda chit fund scam which has happened, Sahara case happened, and Satyam scandal had happened. And then these particular reports were getting prepared. And you see, in India, particularly in my PhD thesis also, I came up with that particular logic, is that we legislate on the basis of knee-jerk reaction. So whenever we are faced with a situation, we come up with a law. We don't contemplate or think futuristic. 5 years down the line, what would be the situation and what law should come up? We never think about it. Probably there are organizations to deal with it, like for example, Law Commission of India, but their mandate seems to be different, and they are taking up issues which are there, important issues, but not futuristic. So this futuristic understanding is very, very important. And I must give credit to my ex-boss, Mr. Anurag Goel, former Secretary, Ministry of Corporate Affairs. In his interactions, I find that he thinks futuristic. So he always, whenever I will have an interaction, he will say, Professor, you are dealing with the current situations. You should think futuristic. And this is another tip which I would like to give to the corporate law professors is think futuristic. So you have to see legislation of the day, but at the same time, put some thoughts or food for thought in minds of your students so that they have this critical and analytical ability to think that how this provision will behave in future, whether that will require some amendment, whether there will be a requirement to change this particular provision. For example, when 2013 law came up on insider trading, I don't know how many of you track company law, but you will find that there is one section which talks about insider trading. Now, that was quite impractical to implement that particular provision. And ultimately what happened is it is not getting implemented. Second important thing is a lot of criminalization of provisions were added to the Companies Act. And when it was there, it was too strict law. And what was the background? Knee-jerk reaction to those particular scams, which I talked about. And ultimately, now there was a requirement of decriminalization. And as you see the company law, most of the provisions now are decriminalized. So these developments, these analysis, these analytical thought processes needs to be brought in your classroom. So this is one important strategy which you can bring forward, because see, I'll tell you, nowadays the students are not interested in reading sections. So if you come up with Section 4 of the Companies Act, Memorandum of Association, these points, that points, probably they will not like it. Ideal situation would be that give them a Memorandum of Association of a latest company which is in controversy. Now they generate interest. Like for example, when I was teaching Securities Contract Regulation Act this year, I gave them Memorandum of Association of Adani Limited. And that was quite an interesting discussion which started happening, that what scope they had and this. So this basically, brings forward the interest in the students. So let me move forward to history. And I think I have spoken sufficiently about history. I hope you got the points which I have talked about. But let me stop this because I think I am having a trouble in, simultaneously watching your chat box and this. So what I will do is I will stop this particular presentation and I will take some questions before, because I think I should not miss anything. Okay. And here we are having, okay. This particular point I always get, share the PPT. Definitely I will share it. It will, you don't worry. It will be shared. And okay. Good. Okay. Fine. So now let me move forward. Unless you are having a question, we will also open up for question and answer session. So let me again go back to the presentation and share it with you. Yes. So we are talking about this. This is an important legislation, and I thought that as teachers, we should talk about it. This is NCLT debate. So National Company Law Tribunal is a new tribunal which has come up. Previously, under the company law, it was Company Law Board, which used to be there, and High Court used to have a lot of power. So it also shows intersectionality, you know. So when we are teaching, our colleagues are also there, right? So who are teaching constitution, maybe they are teaching administrative law, maybe they are teaching some other subject. So you need to interact and engage them as well. So this is a case law which basically engages constitutional law professor as well, because they will be talking about the basic structure of the constitution, judicial power, what is the interface between parliament and judiciary. So these dimensions will be taken care of under this particular. So NCLT case is a very important case as far as company law is concerned, and you all should go through this particular case in detail because it talks about the basic jurisdiction issue, and this follow-up needs to be done. Knowing the regulators, as I said, there are plenty of regulators, and in company law, regulatory space has increased. So as you can see, this is India's map, and you will find that these places, these are the ROCs, Registrar of Companies. And this is another tip which I would like to give it to you, is that try to find out the nearest ROC to you. If you are in, Ranchi or that particular place, you can find ROC in Ranchi. If you are from Calcutta or West Bengal, you can go to Calcutta. Calcutta, there is an ROC. Hyderabad, Vijayawada, Chennai, Bengaluru, Panaji. These are the ROCs. If I'm not wrong, there are about 24 ROCs. And you should connect with the officer there because they will give you the industry connect, because it is important for you to also engage with the regulators. And most of them are good people and they like to interact with academicians. Definitely, they will not share their live cases, but definitely they will be giving you time and you can have an interaction, how things work and that. Sometimes you can call them as a guest faculty for your lecture. So this will give you that, connect with the corporate affairs. Other than that, you will find that there are a number of other regulators under the company law which has emerged. Like, for example, IEPF, Investor Education and Protection Fund. This is an authority which is created by 2013 law under the Companies Act, and this talks about different things. So you can see their website. There is a lot of information around it. They also open up for internships, so your students can go for internship. In fact, you can also interact with them for help. Similarly, there is Indian Institute of Corporate Affairs. I already talked about my previous organization where I worked for about 3 years. It's quite doing a lot of work around corporate affairs. They are also important because they also execute they are the institute which maintains the data bank for independent directors. So that is an official function also they do under Section 150, if I am not wrong, of the Companies Act. They maintain that particular database. Similarly, there is National Financial Reporting Authority. So this is another body which has come up, which is over and above the Chartered Accountant Institute, and they look for financial frauds or auditing frauds which are happening in the companies. The Insolvency and Bankruptcy Board of India, yes, that is a completely a new regulator which has come up with the object of resolving corporate insolvency, and a lot of power given to this particular regulator, and you can see that. SEBI, though not falls under the Ministry of Corporate Affairs, but it is an important regulator from the perspective of listed companies. And I think all our studies which we are doing, either it is mergers and amalgamation, or you are talking about restructuring, share purchase, share sale, everything gets affected by SEBI because most of the times we are having an interaction with a listed company. So it is important for you to follow SEBI. So knowing the regulators, knowing their latest developments is very important. So you should not say that, see, I am teaching company law why should I be concerned about SEBI? Because I'm not teaching securities law. It is not like that, because all these particular things interact one way or the other, and you never know what kind of a question flies in your class from a student. And it will not be good as a corporate law professor. You are not able to at least link them and tell your students where is the source where they could find. And it will be really, hilarious, I must say, that if you're not aware about any of these regulators in your class, if someone asks you, so it is important for you to follow all these regulators and developments. Now, moving forward, the law is emerging with a number of specializations. So as I said, that corporate law or company law is not only limited to the Companies Act. There are plenty of things happening around company law or corporate affairs, and each of these are leading or bringing up a super specialized area. So now it will it will not be something which is alien or something which is what I should say out of the world to say that there is a specialization in corporate insolvency. So there may be an academic who is talking only about insolvency, and there are organizations and there are professors who are dealing only with corporate insolvency. There are people who are dealing or specializing only with securities law, mergers and amalgamation. There are professors who are teaching only mergers and amalgamation, corporate crimes, competition law, dispute resolution, startups are coming up is another area. I talked about ESG. This is the latest trend which is happening, and I'm not aware how many of you are following this, but there is a notification, draft notification, which has come up on life. I think lifestyle of environment. I don't know how many of you follow. Probably when you read environmental law strategies of teaching, you will know about this. But life has come up. Now that is also talking about carbon credits, green finance, all these things will be coming here. And how these companies are discharging their corporate social responsibility is also a very, very important dimension, which is talked about, in these emerging areas. So follow these areas. Try to work in one or two of the areas. You can publish a paper in this area, and that will be really helpful to you people as well as to your students. I will be happy to engage in any of these particular questions in question and answer session on any of these particular topics. Let me move further and talk about value of networks. This is something which I want to give a tip to the students, because to the faculty members, because see, nowadays it is very, very important to have a network. And this network should not only be limited to likes and dislikes on Facebook or probably on WhatsApp. It should be fruitful as well. Like, for example, I am connected to Law Teachers India. Now, connection to Law Teachers India is not only for the purpose that I know Dr. Kalpesh and we are good friends, but it goes much beyond. Where you are collaborating on some research, you are collaborating on some teaching, this particular conference or this workshop or training program is happening. So this helps you to connect different people. So try to utilize that particular network and be part of the network. Don't be a silent spectator of that network as you are in some WhatsApp group wherein admin only posts. So be an active participant of the network. So try to write something, try to write some blog, engage with the students, engage with your colleagues on this area. These are some of the association. The Society of Corporate Law Academics is from Australia. They also have this Corporate Law Teachers Association. So this is a association which you can think about getting a membership. I think it is easily granted, but you need to follow up. Their conference fees are quite high, but it's fine. But you can be part of an international network by connecting with them. Association of Corporate Law Teachers, that was quite an interesting one, which NLU Delhi launched. I don't know what is happening in the latest time. Probably any teachers who is attending from NLU Delhi can update it during Q&A session about this association, but quite an interesting association which came up by the initiative of Professor Harpreet Kaur and the teachers around it. It's quite an interesting one. I also say that you should subscribe to one or two corporate law blogs. I subscribe to India Corporate Law. I find it quite interesting. They post it latest information and this. So as corporate law teachers, you should be part of one of the corporate law blog. And as I said before, you should publish, write on different things which you feel is good for you. And then these are the two. One is Company Secretaries Institute. So ICSI Institute website also you should follow, and probably be in touch with any of the company secretaries who is practicing. So you should make friends with one of the company secretaries. I know it is it will be too selfish to make a friend just because you want to learn from him, but there can be always mutual friendships. I have a good friend and I can name him here, Mr. GP Madan. He teaches corporate governance and he's also a company secretary as well as a lawyer. And I try to interact with him, and many a times we sit together and we discuss how the profession is going, the latest issues, maybe any latest decision. and it is quite an intellectual trait. So try to build up that particular network is also very important. Similar kind of a network you can build with law firms also. So there may be somewhere you will go for a moot court judging, or maybe for interacting, or maybe you can invite someone to your law school, and then there you can talk about or discuss with them or establish that particular connect, because interacting with the industry in company law or corporate law field is very, very important for teachers there. So you will be obsolete in months if you don't keep tap of the latest developments in the industry, which can be given only by the practitioners in the field. So be part of that particular practice is something which I would suggest. And then ASSOCHAM India is another important association. They have a corporate law stream as well. So try to be part of them. I think Mr. Parashar heads that particular thing. Quite a nice gentleman, and you can have an association with them as well, or try to attend some conference of ASSOCHAM that will give you that particular connect of people around it. So this is about networks. I don't know how many of the teachers in this particular workshop told you about this, but I firmly believe that you as teachers nowadays, we are in a connected world. It is very important to develop your networks. Now let me more talk about one case study, and this is my method which I have, and that is why I have said copyright. You can use this method, definitely, there's no problem. Do give citation whenever you use it to your students and this. So when I teach corporate governance, I make my class as corporate governance class. This method may be called role play method. So what happens is, like, for example, this experimented is not a right word. I would say that this is something which I did with my couple of students, a couple of batches. So there were about 50-60 students. So we bifurcated the students at random in a group of 18 to 19 students. And first exercise which I gave it to them was to form a company. So they have to form a fictitious company and they have to think about their idea. So we actually touched upon or revised the whole thing. That is your memorandum of association, choosing the name of the company, objects, capital clause, all these particular things they formed, and they formed their company. They were given also a liberty to choose any existing company and study that and then present it. And one of them, they have to elect a chairman amongst themselves. So that was the chairman of the company. Then all these designations were there in the class. So 18, 19 students, they got all the designation. So whenever we were talking about audit committee, so there were 4 companies sitting in my class already, 6 companies sitting in my class already. And I was interacting with them that, okay, fine, audit committee chair of X company, audit committee chair of Y company. What is your view on this? So this became a really interactive session. And in each class, everybody would come prepared because they would know the company secretaries, and there was a point system which was given. So I would give them the point. It was kind of a gaming thing which we developed. So it was quite an interesting one. Anyone who wants a concept note on this, I have a brief concept note. I can share it with Kalpesh, so he can share it with you people. So that is something which is which you can follow. So try to bring uniqueness in your delivery. That is very, very important. And I must tell you that if you think through, you can also come up with some unique methods of teaching your students. And that uniqueness students like, definitely. And that sets you apart from any other professor who is teaching this particular subject. Coming back to women in corporate law. Now, I want to touch upon this very, very interestingly. And why I want to touch upon this, I will tell you. I read one article, and much before that also, I was thinking about that who are the women corporate law teachers. My apologies if I have not put some more names here, because I just wanted to, bring it forward. Read this article. This article is by Margaret Sachs, and she examines Women in Corporate Law Teaching, A Tale of Two Generations. It is 2006 article and written in US context. However, it starkly demonstrates that what kind of a challenge, women teachers, particularly in the area of corporate law faces. And, I was quite surprised to see that the law subjects are also bifurcated as men's subjects and women's subjects, boy subjects and girl subjects. So corporate law is considered to be a boy subject. And you will find that many male, faculty prefer corporate law, whereas there are female faculty who go more towards constitution, women issues, and that kind of a thing. So this paper discusses that debate. I don't agree to this proposition though, but it is very interesting and important for us to discuss these things as well as corporate law academics, because recently there was a conference of women vice chancellor. I was so happy to see that particular conference. It was organized by IIM University, and interesting thoughts and processes would be coming. So there are perspectives to it, but I would say that I find that there are less number of corporate law teachers, company law teachers, anyways, male or female in India. But when it comes down to female, definitely there are very few, because when I was preparing this particular list, I was thinking that whom to put there, and couple of all of them I have worked with in one or the other capacity. So you can see Ritu in NLU Delhi, Kiran in MNLU Mumbai, Professor Vanita in NUJS. Nandita was my student, but she is in CNLU teaching, leading a corporate law center also. It's quite good. Aratrika in IILM University, doing on commercial courts, a lot of work. Parinita is in Manipal. She's working on insolvency. Lovely Dasgupta is in NUJS and teaches contract and those related. Tilotama is a competition law professor. And we need many more. And that is what I feel, Kalpesh, your movement of this particular training will provide more impetus to the women professors who would like to take up corporate law. And do read this particular article and share your thoughts. It is quite an interesting article from this perspective of women in corporate law teaching. I also wanted to take this particular topic for a simple reason that in company law as well, there are reservation. There is a woman director on the board, and that was mandatorily was required to be provided. And there are researches which shows that how effective it is and what are the challenges in finding good women directors on boards. So I think this debate also should be brought forward. And particularly when you are teaching a class, this also brings forward an important value proposition for your students. So as company law teachers, it is not only our responsibility, to teach the subject, but also to make them lifelong learners, to bring them forward the value proposition. And these are the small occasions when you can bring up the value proposition in the class. Like say, for example, if I am teaching women directors to the students, I would ask them that what do you feel and think about this, whether there should be a reservation for a woman director on the board, or what should be the parameter. And I asked this question in a class wherein there are about 70% of the students who were, girls. And the response was quite surprising. They said that why reservation is required. And these were the female, students who said that, yes, there should be merit on the basis of which it should be selected, and they should come up. So they were contrary, and where the male students were saying that, no, there should be a reservation because we don't find enough. So this kind of a debate, small debates in your class would inculcate that thought process, and what I should say, the curiosity to learn more will be coming to your students. These are some of the excerpts from that particular article. So I think the last one I would read. Many members of the second generation are leery, and they are comparing basically two generations. They have said in the article there are two generations of teachers. And surprisingly, in the first generation, for about 20 years, there was only one professor in US who was teaching company law. And in the second generation, there were about 13, 14 teachers who were there. And she could not list more than 12 or 15, faculty in US who were teaching corporate law. It's quite interesting. Knowing your authors is important. So it is very, very important for you to see that which books you are referring and what you are referring, what you are reading. Reading quality books is very, very important. Quality material is very, very important, as well as producing quality material is very, very important. I see that in company law scholarship, there is a not very much lot happening in our country. And I think more number of qualitative papers are needed in the area of company law and corporate law. Particularly when I look at the US writings, UK writings, and writings from Japan and China, I feel that in India, specifically in the area of corporate law, there is a requirement of more number of research papers which should come up. These are some of the references. I'll share the presentation. So I would say that, and I would like to end this particular session to question and answer is basically tell me and I will forget, show me and I may remember, involve me and I will understand. So this is the basic mantra of teaching corporate law, is that make them do it. If you just give a lecture, probably your students may not follow and they will forget it. If you try to make them the thing, probably they will retain it and they will retain you also as a corporate law professor. The best thing which can happen to you as a teacher is when a student goes in the profession and they remember you, they message you, when they meet you, they tell you that, Professor, you taught us corporate law and it still rings in my ears and it helps me in implementing or doing my job. So I think that will be the best gift which you can get as a teacher. So a good mentor teaches you how to think, not what to think. This should be the mantra which you should follow. And with this, I end this particular presentation. Over to you, Kalpesh. I would be happy to take questions.
Thank you very much, sir, for your enlightening session. I request participant, you can raise your hand. I will unmute you, or you can drop the question in the chat box. I will read out from there. Let me unmute Vishakha. Vishakha, over to you. Vishakha, over to you. Okay.
Hello.
Yes, Vishakha.
Thank you so much, sir, for that enlightening session. It was a very good session. I just wanted to know your views on the concept of independent directors. Do you think that independent directors are actually independent, considering India as a country and the mechanism of choosing them and electing them and the kind of work they do? So I was a bit concerned about.
What is your view, Vishaka? What do you think? Whether they are independent or not?
In theory, yes. In practice, it's a bit dicey. That's what I feel.
Okay, so but from where does this information come from? Is it coming from some paper or it is your hunch or your thought?
It's what I've read so far, sir. That's
Okay.
what.
So if you see the literature, this answer would, if you see the development of the independent directors provision over the period, you will find that this was the situation before 2013 law. So they were really not independent. And that is why there was a requirement of 149 clause 6 clause, wherein a detail was provided, code of conduct was provided. Why that was required? Because the existing system didn't give that particular guidance and people were actually, not following, because it is a fiduciary kind of a relationship which is there of an independent director. And it is presumed that you will have independence. And definition of independence, howsoever, detailed you write, there will be always a loophole which people can find. Okay. Like, for example, women directors. We are saying women directors, but actually whether independent women directors are coming on board, probably not. There are some near and dear ones which are coming. And that is the majority, which research says. However, that does not stop us from bringing that particular provision. That provision is there. Well, sooner or later, things will start going up. But the flip side of this independent directors provision in writing so detailed is that you are not getting a lot of independent directors on board. Good independent directors are not coming on board. Why? Because the responsibility has increased. So they don't want to fall into that particular frame. There are investigations which are happening against them. So things have changed over a period. The proposition, or you can say the hypothesis, that independent directors provision are in letter but not in spirit, probably will be too harsh to the provision. But yes, on and off, there are challenges around independent directors and their functioning. However, the system at present, which is there in the Companies Act, is sufficient enough to regulate it. and it is regulating to an extent that there is a chilling effect on people joining as independent directors. So this is what is my view as far as independent directors are concerned. I hope that answers your question, Vishak.
Okay, Sendra Gupta sir, over to you. It says have the mic. Shalendra Gupta sir, over to you. By the time, let me ask Sendra sir, if you are there, please unmute yourself.
So I see one question from Divyansha, and she's asking that if you don't have a specialization in corporate law, whether you can teach or it will be a disastrous step. Quite a good question, Divyansha. And I will tell you that anytime you can begin of teaching whatever you want. So today, if I feel like I will be teaching medical law and ethics, I can start today. So there is no, bifurcation as such of teaching a particular subject. I always tell my faculty to be open to new subjects. Ideally speaking, every semester you should teach one new subject. Find for a new subject because that is what is the learning for you. Otherwise, you are repeating things. Over a period, things will get repeated. So first time, yes, you will face some difficulty in first semester, but second semester you will be master because you have taught already, and the second semester you will be teaching the same subject. Probably you will gain experience. And the best way to learn something is to teach that. So, take that particular challenge and do justice to it. But yes, it is important to do justice. So don't shirk away from that particular thing. Once you have taken up, yes, I need to teach company law. Put in your efforts. Some extra efforts. You will be a good teacher in corporate law. Definitely, yes.
Thank you, sir. I have unmuted Ashutosh, over to you.
Yes, good evening, sir. And it is, as usual, an intellectually enriching experience to listen to you every time I come to know new things. Sir, my question is, so we are raised in such a culture that there are some really philosophical questions when it comes to teaching company law. And I know, sir, you created your own theory of corporate personality. Sir told me that he created his own theory when theories of corporate personalities were being taught to us. So, sir, nowadays a trend has begun that teaching corporate law has become unfortunately more factual, informative, giving them those factual details are more, but those philosophical details, those jurisprudential or theoretical underpinnings, while defining that social responsibility, sir used to say that it's not an island of richness in the ocean of poverty, to sensitize the students as well. Or when it comes to role of the auditors, they used to say that they are not the hunter dogs to begin with the suspicion, but wherever they find it beyond reasonable doubt, they should make a probe of inquiry. So this sensitization is somewhat also necessary nowadays. So isn't it necessary that there should be an equilibrium by retaining that philosophical real quotient, which is still necessary, alongside that factual metrics and other details?
So, Ashutosh, thank you, and it is a pleasure to hear you after a long time.
Thank you, sir.
And point is that theory, legal theory is basically a realm of postgraduate courses.
Yes,
So the undergraduate courses, the students are more interested in the factual understanding, the procedure. They want to learn that particular thing, and then you can engage with the students at the theoretical level, at the jurisprudential level, only when they understand the basic provision. So if they don't understand the basic provision, they will find themselves lost. As we used to, like, for example, when our professors used to teach company law, and you are right that they would take you to the theories and theoretical discussions and those philosophical portions of it. Those are quite interesting, but those interest can be only generated when you are clear with factual. So this method of teaching requires reading, and there has to be a reading list given to the student. Student should be prepared to read that in detail and then come to the class. Probably that thing is not happening. I am facing a big challenge in getting our students read and come to the class is the biggest challenge which we all are facing. And I feel that the young generation should think about it because it is not only about information. It is about nurturing your thought about it, bringing up new philosophy and thought. Why not any jurist from India has emerged so far? We are having such a rich culture. And I was reading Vikramaditya Khanna on historical evolutions of corporate law, and he has beautifully explained the concept of Sreni during the Mauryan period and Gupta period. That discussion is quite fascinating. None of us are bringing that particular thing forward. Maybe Mimamsa principle, which Justice Kadju talked about in one of the decisions, has not come up. Similarly, there are a number of processes, mercantile laws, which are already existing here in our country, but we are not nurturing them or bringing it forward. We are only talking about jurisprudence which is developed outside the country. So I think that there is a requirement to think philosophically as well. And this can come up probably if you are having 60 lectures in company law, you can devote 2 or 3 lectures towards philosophy. And I've already said that beginning of the session, you begin with historical background. That is also philosophy. So you need to put that particular seed in the beginning. Once you put the seed in the beginning, you will be able to identify in your class out of 60, how many of them are actually interested. Maybe you can form a small group of those students and take them for a coffee or maybe a tea and then discuss that particular philosophy. That will start flowing in your classes slowly. So I think that is the way we need to put it across. So the tapri which we used to go in Nagpur, I think that is very, very important, that discussion. Okay.
Thank you, sir. Sendra, sir, over to you.
Am I audible, Dr. Kalpesh ji?
Yes, sir. Yes, sir. Over to you.
So thank you so much, brother Professor Vijay Kumar Singh ji. It was a very illuminating lecture, and most of us are not teaching company law, but you have generated a lot of interest in this subject. And we are afraid to teach the company law, but you have generated the interest in such a way that we can think over once again to teach this subject. As a student of jurisprudence, I understand that company law is very, very important for the economic justice, which has been talked about in the preamble of the Constitution, because when we think about the Satyam, Sahara, lakhs and lakhs of the common investors, their interests are jeopardized. So friend, just I wish to know from your side, you are expert of the subject, can we take these Sahara, Satyam and other such scams in the classroom as a case study also?
Yes, definitely. Dr. Gupta, I think, first of all, thank you for the compliments. And I must say that I don't see a bifurcation in corporate or any other field of law. I would say I enjoy so much teaching constitutional law. Being a corporate law professor, it gives me a lot of insight, and I always have a discussion. And many a times I argue with my constitutional law professor and tell them that all your socialism is there because we are doing business. If you don't do business, probably your socialism will not work. This is why jokingly we discuss and have an interaction. And practically, if you go at the back of the mind and think about it, probably we had these provisions of socialism and all those particular things in the constitution very much in those days as well, wherein we were facing famine, right? But again, we were not able to implement those particular things. Why? Because we didn't had means. So it is very important to bring that means. And company law is a area which brings that means. Let me put it across this way. During the farm protests, we found that there were a lot of damage which was done to the private properties, private company properties or private properties. And as a citizen, I was thinking that whether it is happening right, okay, fine, you are protesting. But if you are doing a damage to a particular company or to something, you are doing damage to yourself. And as well as there is a dichotomy here which is there. For example, the big industrial houses or big companies, there is a presumption or there is an assumption that whatever money has come up by ill-gotten means is something which is very, very deleterious for the country. Because if you want to grow, you cannot just look at your neighbor's car and say that it has come up by way of illicit money. So this is something which we need to work as overall. And I believe there is a huge amount of responsibility on us academics. And this collaboration between different subjects is very, very important because they should not be seen in silos. So probably What would be the best method is probably in my company law class, I would get a constitutional law professor to teach them directive principles, maybe 2 sessions, and then try to relate it with how it interacts with that. For example, whenever I start teaching Competition Act, I begin with Article 39 and 38 because that is what is the philosophy with which it all started off economic justice. We don't like there should not be detriment to common good, and there should be and you can see the logo of the competition law tagline is fair competition for greater good. So it flows from that particular philosophy and thought. Thank you for that question. I hope that answers your point.
Thank you, friend.
Yeah, thank you very much, sir. Like, sir, I would to share the couple of things. So I have done also LLM business law. So while teaching, I have seen, like while teaching company law, people on the faculty is not talking about the competition law. They really, I start with my class. I spend 1 week on startups. So I can relate those things. So, how to start a business and forms a business, at least 1 week. Sometimes student also ask, sir, when you start companies act, it will come later. First build up this thing. And then I also discussed the competition I told you, and the startup and the commercial code act that also we are not discussing. So, some of things that I keep trying, because again, especially the 3 year course is very difficult to, teach so many things. There is a question, sir, do you teach each subject? What is your pattern of teaching, as we have limited classes from Vani?
Okay. So, see, you have to actually plan your delivery depending on the number of classes. So, if you have a company law, because I am aware that in many of the law colleges, you have only one paper of company law. So, if it is only one paper of company law, then you have to teach the whole Companies Act and philosophy and everything in one paper. So, you have to bring up concept wise. So, look at Avatar Singh. Avatar Singh covers the book of Avatar Singh covers topical wise. So you should concentrate on incorporate maybe historical background and this 2-3 sessions. Then you talk about incorporation. You talk about the major philosophies there. Then you talk about shareholders, members. Then you talk about directors. Then you talk about audit of the company. Then you talk about CSR. That is one portion. Then you talk about winding up or closure of the company. Like this, you have to bifurcate the sessions and topics accordingly so that you give gist of each of these particular things to your students. If you are having 2 papers, then you have more flexibility. Then you can go in much detail and bring some more case laws into it. Then if you are having 5 papers, because if you'll see corporate law honors, there are 8 papers which we are teaching to the students, other than company law 1 and 2. And in most of the law schools, this is happening. So those 8 papers, we are concentrating on corporate finance. There is a separate paper. There is a paper on corporate regulations. We take SEBI regulations in quite detail. Then we are having mergers and amalgamation, one paper. Like this, basically the detailing starts. So it all completely depends on your plan. Never be in a rush to complete 470 sections. You will never be able to do it. So please, chunk it from the perspective of principles. So bring it as a principle and then bring it forward to your students and tell them to study themselves certain things, because that you can give a disclaimer in the beginning of the session itself. Don't set too over ambitious target for yourself, which you are not able to achieve. So that will be actually frustrating for you as well as your students.
Thank you, sir. Any other question, participant? You can unmute.
So there is one question which relates to Sahara. I think there is a Arvind asks a question on Sahara, and he has a apprehension whether this money will be returned. I think there is a portal which has come up with by the government now. So probably the 24,000 crore rupees which is deposited with the SEBI will be distributed. But unfortunately, there are no claimants. That is what I understand from my analysis. So that is there. So please follow that particular news. Yes.
Sir. So the last question, maybe from my side, or maybe it will represent all participants, like regarding the question paper setting. So what kind of question we should ask in the company law?
Yes, that is a very, very important aspect. So nowadays, you see, we are talking about outcome-based education. So I'm sure you all are having your course outcomes, your program learning outcomes. So your question paper nowadays is as per that particular pattern. But however, in your question, generally, you should have 3 types of questions. One question which talks about concepts, definitional type, wherein you are judging their understanding. Then there should be some analytical question, and there should be some application-based questions. So you should set a problem and then try to solve them, like make them a company secretary, give them an issue, they will be able to solve that. So these three things should be there in your question paper. Follow Bloom's taxonomy. It tells you about the lower order thinking to higher order thinking, and frame your questions accordingly. I think that will be more beneficial to your students. Give them some moot courts in because I think all assessments are having some internal component and some external component. So the internal component you should have in detail. You should plan, like for example, in corporate governance, I gave you an example of role play exercise. Similar kind of an exercises you can think for your students, but your end-term question paper should have these three components. It should be application based. Some component major should be application based. Yes. It should not be rote learning.
Definitely, sir. So I, again, I remember the last semester I taught. So I asked two questions, like, Sachin and Dhoni want to start a cricket academy partnership firm. So please draft what should be the clauses in that partnership deal. Same thing, another thing, A and B want to like start a eyewear company that I discussed in classroom. So discuss the clauses for MOA. So that was a thing I also tried this thing, practical thing. So, rather than asking what is MOA, yes, sir.
Sure.
Sorry, sir.
So I think that is a good one. Yeah.
Okay. Thank you very much, sir. I hope we have covered so many questions, and thank you very much, sir. You kept it very short, and then especially the this is one of the best presentations I would say. You discuss regarding regulators. It's not about only companies that you just go and start from sections and these things, but how you connect with, I would say, more than 10 acts, rules, regulatory bodies that will make it more interesting in the classroom. So thank you very much, sir. On behalf of the organized committee, I request Dr. Basira to give a formal vote of thank you, sir. Over to Dr. Basira.
Thank you so much, sir. Sir, this session on teaching corporate law is very insightful, where you have given a number of the context of when a teacher is teaching corporate laws in the classroom. Sir, I could see that you have talked about the importance of historical background of corporate law while teaching, need of the regulations in the context of the increase in corporate sector. You have talked about the report of Shri C.H. Bhabha committee, which should be known by the concerned faculty when they're teaching in the classroom. In fact, sir, it's quite interesting to know that you have also guided us regarding that if we are teaching corporate laws, we should subscribe to business newspapers and websites too. And you have talked about that we should know the regulators also, which is very important part and parcel when we are teaching corporate laws. Also, sir, the case study method which you have discussed with us is very, very important, I believe, not only in the context of corporate laws, but in different laws which we teach in our classroom, sir, which you have talked about, like role play method. That's quite interesting also, sir. Also, sir, interesting part is wherein you have made the observation through an article about the women in corporate law teaching. Probably that is a point of concern when we are talking about teaching not only in the context of corporate law, but also in the context of any other law in this particular field of legal education. And basically, sir, and last but not the least, you also have talked about reading quality material and producing the same, which I believe is very, very important because now the students are concerned more about what we are producing before them. So, sir, thank you so much for this beautiful and insightful session with respect to strategies pertaining to teaching corporate laws in law schools in India. Thank you so much, sir. Thank you, everyone.
Thank you. Thank you very much, sir.
Thank you. Thank you, everyone. And thank you, Dr. Kalpesh, for this opportunity. It was wonderful interacting with you all.
Thank
and
you.
I hope this helps you in your teaching profession. Thank you.
Thanks. Thanks.